For the commissioners. Peter Horchato, please be seated.
Tēnā koe, Ms. Joychild.
Tēnā koutou e ngā kai komihana, ko Francis Joychild, taku ingoa, ko Otho Te Huia o Leone McEnroe, me ngā tamariki o Mua, ngā morihu o Lake Alice. So Council are making these submissions on behalf of Leone McEnroe and on behalf of the group of Lake Alice survivors. But at the beginning, it's important to clarify that many of the Lake Alice survivors were also residents in child welfare homes, either before or after Lake Alice, where they also suffered abuse. So many were and are represented by Cooper Legal and in relation to their claims other than at Lake Alice. So this hearing has been highly relevant to them as well as to Leone.
Just before you go on, just do take note of your speed. Thank you. Thank you.
There are issues relating to redress for the group of Lake Alice survivors that were part of the settlement process that the government undertook with Grant Cameron's clients and later survivors. There are major concerns in this group about the process, which include issues of inconsistency, particularly in relation to costs and quantum, and I appreciate the quantum issues are more severe elsewhere, but there are real concerns about quantum from this group. And they will be spelt out in their statements to the Lake Alice investigation. Now, what Leone McEnroe's evidence disclosed, and to begin with, it's acknowledged the concession that was made this morning that the way things were dealt with were indefensible. Nevertheless, it's important to make comment on this because it's submitted that the evidence by Leone given during this Commission redress hearing, including the documents she provided the Commission, revealed deeply disturbing litigation behaviour, and it submitted abdication of duty by senior Crown lawyers towards a person who sought justice for the abuse that happened to her while in the care of the state as a young person. At the end of the evidence of the Crown this past week, that level of concern must remain very high, it is submitted. Now, it's important to note that the abuse suffered by Leone constitutes major breaches of rights guaranteed by the New Zealand state to its citizens. And I've set these out at footnote 1. Now, the International Covenant on Civil and Political Rights, which New Zealand ratified in 1978, was obviously in operation when Leone filed her claim in 1994. The Convention Against Torture, which was ratified by New Zealand in 1989, was also in place by the time Leone filed her claim. Now, so the rights here were the rights not to be subject to torture or to cruel, inhuman and degrading treatment or punishment under Article 7. In particular, the wording is no one shall be subjected without his free consent to medical or scientific experimentation. It's a right not to be deprived of liberty except in accordance with procedures that are established by law.
Please.
I apologise.
It might be regarded as torture if you're not too careful, Mr. Joychild.
And under Article 10, the right to be treated with humanity and respect for the inherent dignity of the human person. So alongside rights under any convention, there are obligations and duties on the state party, so on the New Zealand government. Under the ICCPR, the government had a duty to provide an effective remedy for violations of those rights. And under the Convention Against Torture, it went further. The government had an obligation to ensure within its legal system that the victim of an act of torture obtains redress and has an enforceable right to fair and adequate compensation, including the means for as full rehabilitation as possible. That's the wording. And I've set out in a footnote statements made by the Committee Against Torture on what that means in practice. So those obligations were in place a good 16 years under ICCPR and 5 years under CAT before Leonie filed her proceedings. Contrary to what the state was legally bound in international human rights law to provide to Leonie, she faced from the state's own lawyers what she describes and what the evidence supports as additional ongoing sustained abuse to what she had already suffered in Lake Alice at the hands of Dr. Leeks and his staff. Her evidence reveals an attitude from Crown lawyers of disinterest, extreme carelessness, and at times callousness towards both the sufferings and indignities vested upon her as a young adolescent at the Lake Alice Child and Adolescent Unit, and towards the impact of the litigation process on her. The impact of that behaviour was cruel. What is most ironic is that the suffering she endured was while she was in the care of the client of the Crown Law Office. Further, it was the Crown lawyer's client who had legal obligations towards her at the time she suffered the abuse and then when she started the process of seeking redress. This point has entirely escaped the Crown Law Office for most of its 3 decades of handling historic abuse cases. And with respect, it appears still not to have been fully registered with the office. And I say that having listened to the Solicitor General for the last 3 days. There was absolutely zero attempt by the Crown Law Office to mitigate the impact of the litigation process on her attempts to seek an effective remedy to the violation of her rights. Now, the evidence of Cooper Legal about its 2+ decades of experience acting for survivors and the Crown's evidence strengthens the concerns shown in Leonie's case tenfold. Leonie's experience cannot be written off as one unfortunate case with a couple of aberrant lawyers. It synergises with other energy before the inquiry. Certainly in her case, and apparently in others, there was not one iota of concern shown for the impact on the victim of the process, the litigation process that the Crown were adopting. The protective role that the courts are meant to play in constitutional arrangements to keep the Crown in check has not been effective or nearly as effective enough to enable complaints to be resolved with speed, fairly, compassionately and consistently. Leonie McEnroe's lawyer, Philippa Gunningham, backed by Robert Chambers QC, used every rule in the High Court rules they could to keep the litigation moving forward. It helped, but it still took 8 years and 7 months before the case had settled and settlement terms effected. And as we all know, Leonie was badly battered and bruised at the end of it. Without a doubt, a new independent body needs to be appointed, well away from the Crown Law Office and government departments, to guide the mediation, evidence collection, fact determination and rehabilitation components of the duty to provide an effective remedy. It also needs to arbitrate on monetary payments that need to be made to survivors of abuse in state care. At best, the Crown Law Office and government departments are and have been hopelessly conflicted in their duty to the Crown as a body that holds the purse strings of the country and the Crown as protector of its citizens. The Crown Law Office has entirely abdicated responsibility to advise on the human rights and treaty duties of the Crown in this sphere for decades. it has shown itself incapable, it's submitted, of being able to develop a process with government agencies that meets its clients' obligations under Committee Against Torture, ICCPR and Te Tiriti. It's time of driving the response, and it is acknowledged that now, particularly in MSD, there are some creative matters happening. Although when one reads about someone wanting a pair of walking boots, one does think about blankets that were given in 1840 onwards to obtain land off people. I mean, all my clients would love a cell phone. Possibly if they were offered a cell phone, they might take one, a smart cell phone. We're talking about real redress for the real damage that was suffered to their whole lives and the lives of their whānau. It's submitted the Crown and government departments shouldn't be given any more opportunities. And it's submitted that one of the most important factors to come out of this redress hearing must be a tectonic shift in the Crown Law Office and its own approach to claims from vulnerable persons alleging breaches by government of their human rights and treaty guarantees. The tunnel vision that has guided the Crown Law Office for almost 3 decades, that its only duty is to protect almost at all costs its clients' purse strings, has got to be thrown to the winds. I just want to recap briefly on Leonie's evidence. She was an orphan by the age of 4 years old and sent to live with a foster family. There she was subjected to neglect and abuse. Her mother, foster mother, did seem to have serious mental health problems, and she kept taking Leonie to medical people saying there was something wrong with her. Unfortunately for Leonie, Dr. Selwyn Leakes, a paediatric psychiatrist, came across her at the Palmerston North Adolescent Clinic when her foster mother had brought her there at age 12, and the rest is history. At the age of 14, she was detained in the adolescent unit during the day and evenings and weekends in the adult unit with seriously unwell adult patients. In all, she was there for 18 months. There was absolutely nothing clinically wrong with her or that justified such detention. And her ACC expert psychiatric reports are beyond doubt on this. Yet she was routinely given painful, strong antipsychotic medication, paraldehyde, with no clinical justification. She was given it for being naughty, such as being disobedient and running over a scoria bed, and that's written in the notes. And that drug had many unpleasant side effects that impacted on her self-esteem, physical and mental functioning, and ability to learn. She was given electric shock. In fact, it wasn't treatment, and a number of survivors call it electrocutions, because she was electrocuted for answering back to Dr. Leakes on the first instance, and then 2 other cases. She spent her evenings with deeply unwell adult patients, one of who attacked her on the head with an ashtray while she was sleeping, causing permanent nerve damage, affecting how she positions her head to this day. So looking at her claim, importantly, she claimed against Selwyn Leakes personally, as well as the Attorney General. And she may have been the only person to have done this. It was plus the other person who Philippa later picked up, and he also claimed against her. It was very important to Leonie that Dr. Leakes be held accountable personally. That was utmost in her interests. She assumed his accountability would be central to the Crown's interests as well, and just as she had taken civil proceedings against him, she expected to ensure that there were criminal proceedings and the Crown would be facilitating and ensuring that they happened. She also expected and specifically went back to Crown Law during the settlement process to ask for Dr. Leakes to contribute to the settlement. In the end, there were huge pressures to settle. She regretfully and reluctantly did, and without ever being told what the contribution was.